pair of cases, both shockingly in Florida, by the way, and they got us wondering if stand your ground, those gun laws, are being misread by gunmen here, and we may just maybe get more clarity out of this case. There were two shootings. You probably know them well here. A guy that you see right there in front of you, Michael Dunn, he pulled out a gun and killed 4 kids, or shot into a car that had 4 people in it, and causing a fatality because the music was too loud. He thought he was being disrespected, and he claims he thought he was threatened. There was no gun whatsoever in the vehicle next to his. In fact, he never called 911 after it. And if anything, he then went over to a neighboring hotel and got drinks. So he right now, this has gone to the jury. We're going to talk about demeanor in this in a little bit. But that case, in addition to the theater shooting, which to me was almost as bewildering, former law enforcement official, you see right there, Curtis Reeves, this man didn't like someone texting on the phone behind him in the previews of the movie theater. You see right there on your screen, turned around and shot him fatally, also injuring his wife who was there with him. Okay, the Zimmerman case, whatever it's worth, I thought they got it wrong. I don't think justice was served. But in this particular case, these seem so egregious, these two cases. Jimmy, there's no way, right, the stand your ground was ever intended or could be applied to cover their actions, can they?
I cannot see that being the case. Absolutely not. I mean, you know, you can disagree with the jury's assessment of Zimmerman, but you had a clear fight. You had a clear issue as to who was on top of who. You had a clear issue of who was the aggressor and who wasn't. You had somebody who called the police immediately thereafter and gave a statement. Here, you've got loud music that is obviously offending somebody tremendously, and then an array of 9 shots fired into a vehicle, and then you have, at worst, an assault with popcorn being responded to with fatal gunfire.
And a former law enforcement official, by the way, who did the shooting. Just so the idea that anybody out there wants to have a debate for another night, that it's good to go pack heat when you go to the Cineplex. But Mayor, explain what the threshold is that the prosecution has to prove or the defense has to argue when it comes to this.
Well, the defense basically has to argue that they're afraid. And the prosecution basically has to disprove that. So the prosecution has the burden beyond a reasonable doubt to show that this person wasn't reasonably fearful. It's a very difficult burden for the prosecution, even in a case where you're talking about popcorn or someone texting in a movie. Because at the end of the day, it's a subjective. You have to go into the mind of the people charged now and determine whether they were reasonably fearful. Now,
but if I'm afraid, okay, I get you. It's not just that I'm afraid. It's that I'm afraid that I am being put not just in reasonable harm, but that I need to use potentially deadly force to protect myself.
You're afraid of deadly force.
Right.
Right. Well, now you can look at the case with Zimmerman. He outweighed Trayvon Martin almost 2-1. He had the gun. Martin had nothing. Now, when you already have the gun, it always begs the question, what are you afraid of? You know you have the gun. Why are you confronting this person? The police said they don't need you to get involved. There's no need for you to put yourself in harm's way. You, in the case in the theater, you're a retired law enforcement officer. You can contact police if you think there's an issue, but why are you causing a confrontation over someone texting in a movie theater?
And most people believe that are following this that in both of these cases there will be convictions. There's some hope from the defense side in the shooting case that was shot into the car because of the loud music, that he may get a lesser charge, hopefully, but that for another day. Doug, I want to bring you in, you guys too. The one thing that came out of this was Michael Dunn decided, or with his attorney's counsel, that he was going to testify. Didn't have to, but given how the evidence was going, that they couldn't even bring in expert witnesses that weren't deemed credible, etc., he had nothing to lose at this point. In his testimony and in his cross-examination, 2 things became apparent. He got more upset talking about a dead dog than he did about the young man that was killed, and that he was answering questions with almost a smirk. Now, I know the jury is always charged, whether it's a civil or a criminal case, to make a decision based on the facts, to get a strict instruction. But how much does the demeanor of a person on trial actually impact when the jury goes in there and makes a decision?
I mean, I think it's huge, because if a jury looks at a guy and they don't like him, and they just don't like him, he gets all the calls against him. And it's a big deal whenever you put, in a civil case also, when a person gets on there, you know, a jury wants to be able to say they helped a good person, they helped somebody out. And if they look at the guy and he's a little...
What's some of the tried and true instructions, regardless of the case, that you always tell a witness here? Not to be too clever? Is it
Honestly, I tell them to be completely truthful and to be yourself. Because if the jury is all looking,
what if
they're
they're
looking.
a jerk?
Listen, sometimes you're a jerk, but you have a good story. But if they detect that you're lying in any way or you're not being truthful, forget it. It's over.
And demeanor comes from your testimony as well. Not only was his demeanor less than exemplary, you know, facts come from testimony. And in this case, you have him saying that he called a detective to voluntarily surrender, and police and telephone records show he did not. He's saying he told his fiancée that he saw a barrel of a gun. She's recalled moments later and categorically, believably, you want to talk about demeanor, look at the two of them, categorically says no, this is his fiancée. So his demeanor juxtaposed with his testimony, which is clearly proven wrong, that's when you're going to get all calls
And you can tell,
against him.
can't you, when you're looking at a jury box, if they don't like the person, they're looking to give them never benefit of the doubt, right?
There's one case that stands out. When I was a prosecutor, there was a guy who just had a scowl on his face. If you looked at him, he looked like he was angry at the world. And we were about to try the case. And one of the detectives came in and gave me some information which made it crystal clear that we had the wrong guy. He was in the area, it was a good faith, but it was a mistake. I have no doubt if we had tried that case, we would have convicted him. And as soon as the case was dismissed, he had the biggest smile, was such a pleasant person, it was amazing, but you would have never got to that point because his attorney may not have had him testify. And if he did, he's testifying under stress. So people they'll judge you based on things that have nothing to do with the case. So you can be a wonderful, come in with a great smile, your mother's father's a minister, and you have all the right things, nice suit, and you could be guilty 100%, and you may the jury will identify with you, you have a better shot at it.
Okay, now, we've all seen lawyer ads. You've never seen one like this. When we come back from this one, I'm going to show you an ad here, and you guys, I'll let you sound off on this. Stay with us, everybody. Trust me, you're going to want to see this.